I want to talk today about a recent case about the taxation of e-discovery costs against the losing party in litigation. There was a recent decision from the Third Circuit Court of Appeals called Race Tires America versus Hoosier Racing Tire. It's a matter of first impression where the court vacated a decision from the Western District of Pennsylvania where the court awarded in excess of $365,000 as taxable costs for activities related to e-discovery such as hard drive imaging, data processing, keyword searching, and file format conversion. This was a case where Race Tires sued Hoosier Racing and Dirt Motorsports, asserting various antitrust violations for the use of certain tires in motorsports. Both parties moved for summary judgment, and the court granted summary judgment on behalf of the defendants. And after that, the defendants submitted a bill of costs to the clerk of the court, and the clerk of the court eventually awarded the defendants, one of the defendants, pursuant to Rule 54D of the Federal Rules of Civil Procedure. One of the defendants was awarded $330,000, and another defendant was awarded $125,000 out of the $145,000 bill that was submitted, which was reduced for a lack of supporting detail. So on appeal, the Third Circuit addressed the issue under Federal Rule of Civil Procedure 54D1, where costs other than attorney's fees should be allowed to the prevailing party. The court then turned to 28 U.S.C. Section 1920, which defines litigation expenses that qualify as taxable costs as fees for, among other things, cost of making copies of any materials where the copies are necessarily obtained for use in the case. So the court focused on the question of whether Section 1920, subsection 4, authorizes the taxation of e-discovery costs for charges related to data collection, preservation, searching, culling, and the like. And the court said generally no, that the numerous services that the vendor performed in this case did not qualify as costs, but only the scanning of hard copy documents, the conversion of native files to TIFF, and the transfer of VHS tapes to DVD, which totaled only $30,000, involved copying costs attributable to activities that were covered under Section 1920. So this decision also overrules a recent decision from the Eastern District of Pennsylvania in re aspartame antitrust litigation, which was one of the first decisions in this circuit to deal with the issue of whether to shift costs and which costs are taxable to the non-prevailing to the prevailing party. There, the court awarded more than $500,000 for activities which included creating a litigation database, storing and hosting data, conducting keyword searches, conducting privilege searches, and capturing metadata. So the takeaway from the Race Tires America case, first of all, to be proactive. Think about this issue before the litigation gets started, even before you hire a vendor. And it's important to tell the vendor that you need detailed invoices and explaining what the activities are, because in this case, $25,000 or $20,000 was reduced because there was duplication, and then additional monies were not covered because the court didn't understand what the vendor was doing. So it's important to get detailed invoices. That increases the chances that the cost will be covered. It's also very important to understand who your audience is and make the invoices understandable for the court and for the opposing party. If you consider your audience, you increase the likelihood that you're going to recover the cost associated with these various e-discovery activities.